Alex here with a legal nuts and bolts video on the complaint. You could really use this for any initial pleading that's filed in a case. Some of them are called petitions, and there may even be other names that I just am not aware of. But typically it's the complaint that's filed in a case that opens the lawsuit and gets everything started. I've been asked to do videos on this topic in the past, and I turned it down because I always felt like it was one of those topics that an attorney would be better at covering. And there are videos all over YouTube by attorneys that actually explain what should be in a complaint and how it works and all that. But every now and then I'll have an epiphany on how to explain something in a way that I think my viewers, non-attorneys, because I am a non-attorney, understand a lot more. I don't know if I want to use the word intuitively. I don't know. Let's just go into the video. Here is my explanation of the complaint. The first thing that I usually tell people when I talk about topics such as these is that usually as non-attorneys, we think that we are fighting the whole case the whole time at every step through the process, which is not the case. Different parts of the legal process require different things. They have different purposes, and what you are doing when you just try to fight and prove the entire case at every part of the process is frustrating the judge for the most part. The attorneys too, but the judge, because certain things need to come out at certain times, and we as non-attorneys don't know that, so we just continue to just dump the whole case on the judge every single time that we can, every single opportunity that we can. And this is one of those many times that happens. There is the initial phase where you're setting up the lawsuit, then there's discovery, then you actually go to your trial, and then sometimes you have some post-judgment stuff to do. But anyway, what are you doing when you file the complaint? That very first thing, that very first initial pleading. What you are doing is you are setting the boundaries of the case up. It's like you are taking this box to the judge, and you are going to be putting things in that box, and anything that is in that box is what the court has the power over. There's two types of things that you're going to put in there. One is targets. It could be people, it could be companies, whatever it is that you are targeting with your lawsuit. Whoever it is that you are trying to take something from, whether it's money, custody of a child, etc. Those are part of what goes into that box. Those are the people, or as I mentioned earlier, the business entities. The other thing that you're putting in there is issues. What issues do you need the court to go over? And again, I'm kind of speaking this in a sense of sort of what I really want to make clear is you're actually giving the judge the authority to do these things. You're giving the judge the authority over these targets, these people and these business entities, and also over these issues. So I know that this is a sort of plain way to explain to you, how you're setting up the boundaries of the case from the get-go in the beginning. But you also have to realize that the judges don't have this sort of godlike power to do whatever they want to anyone they want, any time that they want to. This initial paper that you're filing, this initial pleading, is you quite literally giving the judge the power that he or she needs to even do anything in the case. Get your head around that until you set this up, the judge doesn't even have power over these people. The judge doesn't even have power over these issues. We have to step away from this idea that once you just get in that courtroom and you're talking to that judge, now they can just do whatever they want to anyone that they want anytime, and they just can't. So it's very important that you get that initial pleading done right, because if you don't, the judge won't have the power to even help you. You have to get your head around that fact that literally they will lack the power, which for us, as I mentioned a few times already, is a complete foreign idea. Judges, to us, to non-attorneys who've never been to court, judges can do anything. And the reality is so far from that. So that's all you're doing with the complaint. You're not trying to prove your case. That's what a lot of non-attorneys don't understand, and so they try and attach all this evidence to it, and they try to persuade the judge. That's not the point. You are just setting up those boundaries. You are just giving the judge the authority that he or she needs over the issues and the people. That's all you're doing. It is very, very limited, and when you go beyond that, it doesn't look good, and it just frustrates the court, because now they have to sort of figure out how to to sort of draw all the inferences over who it is you're targeting and what issues you're bringing to the court. And it just creates more work for them. So try and stand apart from all the other non-attorneys and get this done right. So now that you know this, you have to know literally what goes into the complaint or the petition or whatever initial pleading it is. It's allegations, just allegations, nothing else. No proof is needed yet. There are rare exceptions to this, and that's because the legislatures of our states have enacted statutes that say so. But unless they have done this, that's all it is. One example is if you're trying to sue somebody for professional negligence, you also have to include what they call an expert's affidavit. Why? Because the law says so. The legislature went and literally created a law commanding you to include that affidavit with your complaint. But unless there is some law that mandates something like that, you don't attach anything to it. It's just a complaint. It's just a list of allegations, and that's all it is. So each of those allegations is either going to accuse a person / business entity, company, whatever, of doing something, and or, I put it and or there because some people just list the parties separately from the allegations, and other people list the parties within the allegations and or the issues that are going to be before the court. So like if you got hit by a car, you might accuse somebody of having struck you with their car, and then you might include like where it happened, like the location that it happened, what your car was, what their car was, stuff like that. It's just allegations, and each allegation that you list gives the court some kind of authority over a particular issue or a particular target. So when you allege that somebody did something, that particular person has been put into the box. When you allege that your car was hit and that it was damaged, that particular issue was put in the box. Anything that's not in there, the court cannot do anything with later on. So if you later on have all these other issues that you need the court to address, or all these other people that might be liable, if you didn't put them in your complaint, they're not in the box. They're out of the boundaries of the case. The court can't do anything to help you. It's not that the court doesn't want to, it's that the court literally lacks the power. You did not give the court the power that it needed. There are some technical details that I'm leaving out. So it is true that when you've listed these parties or these business entities or companies, that you're giving the court jurisdiction over those people. But there's another part that I'm kind of leaving out there. You do have to serve them. And that's required in Nevada. That's under Rule 4 of the Rules of Civil Procedure. That is a part of the process of giving the court jurisdiction over that particular target. So naming them in the complaint is required. It's mandatory, but that's not enough. You also have to get them served consistent with the Rules of Civil Procedure. Once you do that, then the court has jurisdiction over that person. You have given the court the power to do something to that person by naming them in the complaint and by serving them. When you file the complaint, when you take that paper and you get that file stamped, you are giving the court jurisdiction over you. You are submitting yourself to the jurisdiction of that court. Now the court can do things to you too. So the third thing that I haven't mentioned is the issues. As you outline, as you allege things in that complaint, the court is going to have jurisdiction, subject matter jurisdiction, over those particular issues that you have included in the complaint that you have alleged. So, by the way, guys, I do have some topics that go into some of the details here. Take a look at the video, Personal Jurisdiction. That covers the jurisdiction that the court has over the targets of the lawsuits, so the people. And also the filer, the plaintiff too. The plaintiff has submitted themselves to the court. And then the other video is called Subject Matter Jurisdiction, and that's giving the court the jurisdiction over those issues that you've alleged. I hope that this helps people. Oh, one more thing, affirmative defense. Well, no, that goes into the answer. I guess I could talk about that in another video. Anyway, this video is just the complaint, which is the plaintiff or the person who was complaining, bringing issues to the court, setting up the boundaries of the case. And I guess that's everything that I can think of without getting too technical. I think that this video might really help a lot of people. You will understand that when you file the complaint, you are doing all of the things that I described earlier in the video, and you don't have to worry about proving everything now. I'll very briefly explain that you will do that later. Later on, there are a few phases. For example, the discovery phase, where you'll actually start to gather evidence, and you'll start to Sometimes parties will try to throw your case out using a variety of different mechanisms. Maybe they're trying to use a summary judgment motion against you to close the case before it even gets to a trial. I'm not going to say that that's the point in time where you're going to prove everything, but that might be the point in time where you can argue, hey, based on these pieces of proof that I have, I mean, we should get to a trial on these issues because this isn't clear. This can't be resolved yet. These things, I guess, I might cover with different videos. In fact, I think I have a video on the topic of summary judgment already anyway. So I hope that this video is very helpful to my viewers. Think of the complaint in a completely different way than you may have ordinarily thought of it when you hadn't seen this video yet. With all that being said, if you have any questions, feel free to post those questions down in the comments below, and I will see you guys next time.